Hello guys, I am Anshika Agrawal. I am working as an intern in LEXIS and Company. Today I am going to discuss on the topic contempt of court, in which I will cover various aspects of contempt of court, like what is contempt of court, what are its essentials, what is importance, what is Contempt of Court Act 1971, and about Article 129 and Article 142 Clause 2, also the landmark judgment of Prashant Bhushan sir case and various other things. So, let me introduce you to the topic. Term contempt of court is a generic term descriptive of conduct in relation to particular proceedings in a court of law which tends to undermine that system or to inhibit citizens from availing themselves of it for the settlement of their disputes. This definition is given by Lord Diplock when he was giving the judgment in the case of Attorney General versus Times Newspaper Limited. This term, contempt of court, can be easily understood as in when we are disrespectful or disobedient towards the court of law, which means that we willfully fail to obey the court order or disrespect the legal authorities. And the judge has a right to impose sanctions such as fines or can send the contemptor to jail for a certain period of time if he is found guilty of contempt of court. This term can also be understood in terms of freedom of limits of the judicial proceeding. As we know that all judges in courts can give judicial proceedings which have a certain limit in which it has the freedom to make any judicial proceedings, and anything which curtails or stops it in making any judicial proceeding which is of necessity can amount to contempt of court. Halsbury, Oswald and Black Hodges have also given the definition of contempt of court, and in addition to that, they have talked about its misuse and its wrong interpretation and also its broad prospectus. In India, the concept of contempt of court is defined in Section 2A of the Contempt of Court Act 1971, which has broadly been described as civil contempt or criminal contempt. There are two articles in the Constitution of India which talk about the contempt of court, and these are Article 129 and Article 142 Clause 2. So, what does Article 129 says? It says that Supreme Court shall be the court of record, and it has all the powers of such courts, including the power to punish for contempt of itself. The court of record means a court having its acts and proceedings registered for everlasting memory, or that memory which has no end and is evidence of proof. The truth of these records cannot be questioned, and also these records are treated as a higher authority, and anything stated against the truth of these records comprised contempt of court. So, Article 142 Clause 2 talks about the contempt of court. This article says that when any law is made by the Parliament on the provisions mentioned in Clause 1 of this article, the Supreme Court has all the powers to make an order for securing any person's attendance, production of any documents, or has the power to give punishment to anyone for its contempt. This also does not mean that the Supreme Court can do anything against the right of personal liberty if it has the power to punish for contempt of court. We know it is the guardian of all the rights that we get from our Indian Constitution, so it has to safeguard the rights and cannot violate these rights itself. Now I am going to tell you about how the contempt of court get originated. The legal system that we see today is a summit of the long journey which is started from the divine rule that was in proclamation to the natural law, and more further, the positive law that we see today. Contempt of court is a matter which regards that justice should be administered fairly and also punishes anyone who aims to hurt the dignity or authority of the judicial tribunals. This law had its origin from the medieval times when the royal powers of the monarch were transferred to the court, and at this time the monarch was believed to be appointed by God and everyone was accountable to him. This power of accountability clearly depicts the same accountability the Supreme Court possesses nowadays under Article 129 and Article 142 of the Indian Constitution against its contempt. In the English medieval ages, the judiciary was an important tool of the monarch. At that time, these judges and legislatures were representatives of the divine rule, monarchy, and these judges and legislatures played an important role in legitimizing the functions of these monarchs. The king was the superior head of the justice, and this power he was given to the judicial system. And if anyone or the king himself disrespect or caution the courts, it became a challenge to the superiority of the king as well as to the wisdom. So, this can be seen as although the source of law has transferred in the society, the unquestionability quality that a king enjoyed was upheld by the monarchy. There is a case of contempt against J. Justice Elman in the year 1765. A statement was made by the Irish judge Sir Adlai Wilmot in regard to this contempt attacks on the judges. In this case, Elman has published a pamphlet labeling the decision of the bench of kings, and the judgment given by the judge had been given rise to many questions of several aspects of the judiciary which had not been questioned yet. This matter gives a great push in the establishment of the contempt of court. The judgment also recognized that the unbiasedness is also one of the features of the judiciary in making the decision which makes the institution different from its peer institution. Furthermore, let me explain you about the Contempt of Court Act 1971. This act extended to the whole of India, and it has also provided that this act shall not apply to the state of Jammu and Kashmir except in certain conditions in which the provisions of the act is connected to the contempt of Supreme Court. Another thing is that this act provides the definition of contempt of court which has not been given by the earlier act of contempt of court. This act under section 2A defines contempt of court as civil court and criminal court. There is a case of Nurali Babul Thanewala versus KMM Shetty, in which an undertaking was given to the court in civil proceedings by a person on the faith that undertaking was correct. The court sanctions a course of action in regard to that undertaking, but the undertaking seems to be incorrect. Hence, this was considered as misconduct and amount to contempt of court. In this act, there are several provisions given that it does not amount to contempt of court. Although these provisions have to be dealt with, these are innocent publication of a matter or its distribution does not amount to contempt of court. Second, publishing of fair and accurate reports of the judicial proceedings does not amount to contempt of court. Third, fair criticism on judicial acts does not amount to contempt of court. Next, in this act, the High Court has been given the power to make decisions on the matter which is outside its jurisdiction. Punishment for contempt of court has been given in this act, and also what type of misconduct not amount to contempt of court has been given. How can we deal with that contempt has also been given. The judge, magistrate, or any other person who is acting judicially can also be contempt for their actions. Also, this act gives certain limitations where this act does not apply. This act does not apply to the courts of Nyaya Panchayat and other courts of the village. This act repealed the old existing act of contempt of court which came into force in 1952. Guys, do you know the essentials of contempt of court? If no, don't worry, I will tell you. Firstly, disobedience to any type of court proceedings, its orders, judgment, decree, etc. should be done willfully in case of civil court. Secondly, the criminal court publication is the most important thing, and this publication can be either spoken or written or by words or by signs or by visible representation. The court should make a valid order, and this order should be in knowledge of the respondent. The action of contemner should be deliberate, and also it should be clearly disregard of the court's order. These essentials should be fulfilled while making someone accused of contempt of court. For example, if Akash, a person, has to prove that the other person named Riya is guilty of committing an act which is an offence in the court of law, then he has to show the court that the offence which Riya has done is fulfilling the essential required to commit that act or not. If the essentials of that will be fulfilled, then he will be liable for the act. Similarly, every offence has certain exceptions that has to be fulfilled for making the person liable for doing that act. The contempt of court concerns the fair administration of justice with the intent to punish acts hurting the dignity and authority of the courts. The charge to safeguard the majesty of the judiciary in India was aggravated to the judiciary itself by arming it with contempt of jurisdiction. Now, let me tell you why contempt of court is important. Contempt of law means being disobedient to a court of law or towards its ruling. The recognition of contempt of court and to punish for contempt is essential for a nation such as India, which is based on the concept of rule of law, which requires supremacy of law, since the judiciary is considered as the last bastion of hope and justice for the citizens of any nation. According to the Supreme Court Bar Association vs. Union of India case, the object of punishment is both curative and corrective, and these coercions are meant to assist an individual complainant to enforce his remedy, and there is also an element of public policy for punishing civil contempt, since the administration of justice would be undermined if the order of any court of law is to be disregarded with impunity. The concept of court of is several centuries old. In England, its common law principle that seeks to protect the judicial power of the king, initially exercised by himself and later by a panel of judges who acted in his name. Violation of the judges' orders was considered as affront to the king himself. Over time, any kind of disobedience to judges or obstruction of the implementation of the directives or commands and actions that showed disrespect towards them came to be punishable. There were pre-independence laws of contempt in India. Besides the early high courts, the courts of some princely states also had such laws. When the constitution was adopted, contempt of court was made one of the restrictions of the freedom of speech and expression. So, now I would like to throw some light on the landmark judgment of Sir Prashant Bhushan. It was the suo motu contempt case in which the bench consists of Justice Arun Mishra, Justice B.R. Gavai, Justice Krishna Murari. So let me first introduce you to the case. The conviction and sentencing of Prashant Bhushan, one of the India's leading liberal lawyers, for contempt of court was deeply troubling. The Indian Supreme Court judgment comes at a critical moment in India's constitutional history, marked by serious concerns about whether the court is fulfilling its duty as a protector of civil liberties. The Bhushan case, while dispiriting, is not entirely unprecedented. Politicians and writers critical of the court have been prosecuted for contempt before. However, the case is still worth examining because it serves as a reminder that institutions, including courts, are merely, to paraphrase Emerson, the lengthened shadows of man. It reminds us that the judicial office is not somehow transformative, that judges do not abandon their prejudice when they don the robe. So what was the contempt of court against Mr. Prashant Bhushan? Supreme Court, upon the complaint filed by Mehak Maheshwari, took suo motu cognizance of the tweets posted by activist and advocate Prashant Bhushan on his Twitter handle and held him guilty of contempt of court for lowering the authority of the court through its tweets. So here are the facts of the case. The contemptor, Prashant Bhushan, is a senior advocate with more than 3 decades of experience pursuing public interest litigation in several high-profile cases. On July 22, 2020, a petition was filed against him and for the Supreme Court of India, bringing to the court's notice 2 tweets published by Prashant Bhushan. The alleged tweets made against the Chief Justice of India and Supreme Court highlighted a declining trend of the independence of the judiciary and the court's role in protecting India's democracy. The tweets were eventually blocked by Twitter. They were quoted as: the first tweet was, "CGI rides a 50-leg motorcycle belonging to a BJP leader at Raj Bhavan, Nagpur, without a mask or helmet at a time when he keeps the Supreme Court in lockdown mode, denying citizens their fundamental right to access justice." Second tweet was, when historians in future look back at the last 6 years to see how democracy has been destroyed in India, even without a formal emergency, they will practically mark the role of the Supreme Court in this destruction, and more particularly the role of the last 4 CGIs. By an order dated July 22, 2020, the court registered suo motu contempt proceedings against Prashant Bhushan, arguing that the tweets brought the administration of justice into disrepute and were capable of undermining the dignity and authority of the institution of the Supreme Court in general and the Office of Chief Justice of India in particular in the eyes of the public at large. On behalf of Contemptor 1, Mr. Prashant Bhushan learned Senior Counsel Shri Dushyant Dev is appearing before the court, and on behalf of Contemptor 2 Twitter, Shri Sajjan Purwala learned Senior Counsel has appeared along with Mr. Priyadarshini Banerjee and Mr. Manu Kulkarni. So the issues before the court were whether the tweets published by Mr. Prashant Bhushan are healthy criticism of the Indian judiciary or has dashed the public confidence in the institution of the Supreme Court. Second, whether these tweets were criticized by the CGIs as individual or CGI as a CGI of the Supreme Court. Thirdly, whether the acts of Twitter have also tempered the reputation of the Indian judicial system. So the final verdict of the Supreme Court was that the Supreme Court sentenced advocate Prashant Bhushan to a token fine of ₹1 in the contempt case against him for his tweets criticizing the judiciary on August 31, 2020 and found him guilty. On August 25, the bench of Justices Arun Mishra, B.R. Gavai and Krishna Murari reserved its order on Bhushan's sentencing after finding him guilty of contempt of court for his tweets. While pronouncing the verdict, Justice Mishra said, "Judges are not supposed to go to the press. Their comments outside the court should not have been relied on." The bench went on to note that it had given Bhushan several opportunities to express regret for making his contempt statements. It also stated that Bhushan gave publicity to the events surrounding the contempt case by going to the press. Said court's decisions should not be preempted by publication of opinions in the press. However, the bench ultimately saw it fit to impose a token fine of ₹1 on Bhushan. The bench made it clear that if Bhushan defaults on payment of the fine, he may be sent to prison for 3 months and may be debarred from practicing for 3 years. Bhushan has filed a supplementary statement reiterating his position to stand by his tweets and has refused to apologize. When the supplementary statement was considered by the court, senior advocate Rajiv Dhawan had urged the court not to make Bhushan a martyr by imprisoning him. The court, however, pointed out at AG Venugopal that Bhushan did not express regret, but instead chose to reiterate his position of not apologizing for the contentious tweets. In a candid dialogue that followed between the bench and the lawyers present at the hearing, the court expressed the hurt and pain caused to the institution when such allegations are made. On August 14, the Supreme Court had found Prashant Bhushan guilty of criminal contempt of court for 2 tweets criticizing the judiciary. The tweets in question were posted in June. This first tweet pertained to the Bhushan's commentary on a picture of Chief Justice of India S.A. Bobde on a high-end motorcycle, whereas the second Bhushan expressed his opinion on the role of last 4 CGIs amid the state of affairs of the country. Mr. Prashant Bhushan accepted order of Supreme Court and submitted the penalty. He believes that what the court believes to be a contempt is the highest duty of a responsible citizen of the country. In a press conference, Mr. Bhushan has said that he shall seek his right to review. The bench referred to the American case of Rex versus Elman to hold that authority of court extends the deference and respect that is paid to judges for these acts. It also noted that this authority is exercised not to vindicate the honor of the judge who was personally attacked, but to uphold the majority of law. Mentioning its verdict in Arundhati Roy case, the bench also sought to bring out a difference between hostile criticism and fair and bona fide criticism, nothing that the letters from good faith and public interest. Now, the question arises, is the court scandalizing itself through its verdict? First, the evergreen debate over the fundamental freedom of speech not being absolute for everyone comes to force. The Supreme Court had noted in C.K. Taptari versus O.P. Gupta that the law of contempt constitutes a reasonable restriction on the freedom of speech and expression as permissible under Article 19, Clause 2 of the Constitution. In Para 56, the present bench also observed that a scurrilous attack on a judge in respect of his or her past judgments or conduct has an adverse effect on justice, thereby constituting contempt. When we look on Bhushan's tweet, the only apparent inference that can be made is that a citizen is speaking in anguish about the judiciary's approach towards certain happenings in the country. Even when he notes the action or inaction of the past 4 CGIs in destruction of democracy in the country, no interference in administration of justice is visible. Second, the pertinent question on whether or not there even exists a standard to hold contempt has been triggered by this verdict. In Narmada Bachao Andolan versus Union of India, the apex court noted that distorting and misrepresenting the court's direction by vicious stultification and vulgar debunking impossible under the freedom of expression. However, despite noting that Arundhati Roy and Medha Fatka's statement on the court's handling of legal and humanitarian issues surrounding the contribution of the Sardar Sarovar Dam had a tendency to scandalize administration of justice, the bench refrained from taking action for contempt. What I analyzed from this case is that the apex court has rightly adjured the case as hand. What is the first contemptor had said was not mere opinion and bona fide intention, but an attempt to attack the institution and its chief justices. However, the court at the same time has also been a lot harsh on the contemptor here. The contemptor has been asked to submit a fine. If he does so, it means that he accepts the charges or face imprisonment for 3 months and shall be barred from practicing in the court for 3 years. This is the misuse of power by the court to take him choose between acceptance of charges and or to practice in this court. However, as also mentioned earlier, the contemptor has expressed his desire to invoke his right to seek review. Finally, I would like to conclude my topic. It is surprising how the judiciary continues to employ the weapon of contempt to silence free speech, even when Britain, the country from where we have adopted the present law, abolished criminal contempt back in 2012. A series of judgments of the Supreme Court have shown that the grounds for holding contempt under the Act of 1971 are vague. Earlier, in August 2020, and Ram Arun Shourie and Prashant Bhushan moved the court on the constitutional validity of the Act. Even after weeks, the petition is yet to be listed. So, it is concluded that criminal contempt that punishes fair criticism of the judiciary has no place in a democracy that cherishes free speech as one of its core values. Now, I would like to ask you all that what is not contempt of court and whether truth a defense against the contempt of charge. Do please answer these questions, and thank you.